So let's talk about the difference between utility patents and design patents. Utility patents grant an inventor a limited monopoly over a new functional invention. The term is 20 years from the date of filing. Design patents grant a limited monopoly over the original ornamental design over the product, and the term is 15 years from the date of issuance.
And again, this is an important consideration for any business. A few years ago, we represented a client who had an iconic design that was essentially a hobo bag, two round handles from which hung a bag, whether it was made of leather or canvas or something else, and it was attached to the two round handles by straps. When we first began representing this client, we asked whether there were any iconic designs that they wanted to protect, and at the time they decided they didn't. Unfortunately, a few years later, the hobo bag gained a significant amount of notoriety and popularity, and at that time they returned to us and asked, is there something that we could do at this point to protect that design? And essentially it was too late at that point. So this is another consideration that designers, brand holders, mark holders need to pay attention to. Is there something iconic? Is there something that you want to protect on a going forward basis? But you also need to be careful, because if designs are seasonal, if they're trendy, although it doesn't cost a huge amount of money for a design patent, it's not something that you would want to do for every design, every product, because it only has a certain limited lifespan. But if there's an iconic design, an iconic product, strongly consider getting some sort of protection for that.
Absolutely. Okay. Design patents can cover ornamental designs over items such as eyeglass frames, handbags, jewelry, and footwear. Design patents offer protection based only on the pictured designs in the patent, and this is very important. We have an example here for you. In 2012, Lululemon sued Calvin Klein, alleging that certain pants that Calvin Klein sold infringed several of Lululemon's design patents, entitled Pants. And this case was filed in August 2012 and settled 3 months later, as these cases often do. But you can see here the design patents that were at issue.
And this also is similar to a case that we had a number of years ago where we represented a client who had to redesign the hardware that it incorporated in its men's loafers because the design was too similar to a competitor's design that was covered by a design patent. Unfortunately, our client's design was apparently inspired by the competitor's classic horse bit design. The client unfortunately needed to redesign the hardware for the shoe, needed to pay a royalty to the competitor, and needed to cease producing and shipping shoes, so it set it back a season on its shoe production. So designers need to be careful with inspirations. Oftentimes, designers inspire one another, but check to make certain whether or not there's some sort of protection if it's possibly an iconic design for another brand.
That's good advice.